This will be the People News. One more time at it, okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Let me try to get this little one out a little bit. I'm not an attorney, and I'm not giving legal advice. Okay, anything I say or do is just my opinion. My opinion only. Okay, is due to my research, not to your research. I'm hearsay. All right. So, therefore, don't even take your lawyer's advice. And I'm not giving advice. Do your own research and make sure your attorney is operating in good behavior. Okay? You got to double check all these things. Let's just proceed forward on this right here. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. That sounds like a flashback.
Dating back at least to the time of Socrates, some early societies decided that certain disputes, such as whether a person committed a particular crime, should be heard by a group of citizens. Several centuries later, trial by jury was introduced to England, where it became a fundamental feature of the legal system, checking the government and involving citizens in decision-making. Juries decided whether defendants would be tried on crimes, determined whether the accused defendants were guilty, and resolved monetary disputes. While the American colonies eventually cast off England's rule, its legal tradition of the jury persisted. The United States Constitution instructed a grand jury to decide whether criminal cases proceeded, required a jury to try all crimes except impeachment, and provided for juries in civil cases as well. Yet, in the US today, grand juries often are not convened, and juries decide less than 4% of criminal cases and less than 1% of civil cases filed in court. That's at the same time as jury systems in other countries are growing. So what happened in the US? Part of the story lies in how the Supreme Court has interpreted the Constitution. It's permitted plea bargaining, which now occurs in almost every criminal case. The way it works is the prosecutor presents the accused with a decision of whether to plead guilty. If they accept the plea, the case won't go in front of a jury, but they'll receive a shorter prison sentence than they'd get if a jury did convict them.
So, you know what they call that? They call that retaliation.
Of a much greater prison sentence after a trial can frighten even an innocent defendant into taking a plea.
Gee, you think? You wonder why people in prison? Because they thought they was innocent and they decided to fight it. And what? The judge decided to do retaliation with the prosecutor. That's why.
In the 19th century and the 21st century, the proportion of guilty pleas has increased from around 20% to 90%, and the numbers continue to grow. The Supreme Court has permitted the use of another procedure.
Now sit and think about that. Why is it 98% conviction rate, people? Just a food for thought. It's a little higher than that here in Texas.
That interferes with a jury, called summary judgment. Using summary judgment, judges can decide that civil trials are unnecessary if the people who sue have insufficient evidence. This is intended only for cases where no reasonable jury would disagree. That's a difficult thing to determine, yet usage of summary judgment has stretched to the point where some would argue it's being abused. For instance, judges grant fully or in part over 70% of employers' requests to dismiss employment discrimination cases. In other cases, both the person who sues and the person who defends forego their right to go to court, instead resolving their dispute through a professional arbitrator. These are generally lawyers, professors, or former judges. Arbitration can be a smart decision by both parties to avoid the requirements of a trial in court, but it's often agreed to unwittingly when people sign contracts like employment applications and consumer agreements. That can become a problem. For example, some arbitrators
Does family court sound familiar?
may be biased towards the companies that give them cases. These are just some of the ways in which juries have disappeared. But could the disappearance of juries be a good thing? Well, juries aren't perfect. They're costly, time-consuming, and may make errors.
I had to say, juries nowadays is more ignorant of the law than there was 100 years ago, people. Because today we diluted the law down so much, which is going to be a next video or so, about how they diluted the law.
And they're not always necessary, like when people can simply agree to settle their disputes. But juries have their advantages. When properly selected, jurors are more representative of the general population and don't have the same incentives as prosecutors, legislators, or judges seeking re-election or promotion. The founders of the United States trusted in the wisdom of impartial groups of citizens to check the power of all three branches of government. And the jury trial itself has given...
But we're going to stop there, right? So, these people is trusting a known liar, and these people, since they're trusting a known liar, has good faith, believing the judge is going to be good, and a court appointed attorney is in turn around helping him, because now his job became harder. So if you did not make a plea, he's not happy with you. This guy's not happy with you, and this guy over here is not happy with you. So they're going to say, hey, please, jury, give him 20 years.
Ordinary citizens a central role in upholding the social fabric. So, will the jury system in the U.S. serve?
Let me do it a different way. So with the trickery of minds between the two attorneys, the jury is going to be in favor of going to jail due to your defense attorney misled the jury to believe in the prosecutor, just out of retaliation. Now, I'm not an attorney, not giving legal advice. Could I be wrong about this? Absolutely. However, if I don't trust them because they've been known liars, my mom and dad always told me, do not trust liars.
Dive into the future?
These are We the People News. Till next time. Bye, y'all.